present with the state, and the defendant is present with his attorneys, John Brusek and Victoria Cole. Today is the day set for the judgment and sentencing. The court does know that there's a motion for new trial that was filed on May 6th, 2024, and then a resistance that was filed approximately 12 minutes ago. Did the defense have an opportunity to review the resistance?
I have not seen it, Judge.
You don't have your computer with you either. Do you want a chance to review the resistance?
Judge, I would ask that we be allowed to review it. Not necessarily that we need to set it in for a new hearing, but I'd like to look at it first, and then I may be able to just let you know.
Okay. I do have a copy here.
Thanks, Judge.
Okay. So at this time, we'll take up the motion for new trial first. I'm assuming since Mr. Brusek, you wrote the motion, you're going to make any additional statements?
I am, Judge.
Okay.
Judge, we do believe that Mr. Teslik was denied a fair trial. We respectfully, Judge, believe the jury was improperly instructed on matters of law, and that the verdict was contrary to the law and contrary to the weight of the evidence. Anyone following the law and following the instructions could not have watched that exhibit A1 and come to the conclusion that it was not a first-degree burglary. Ignoring that, judge is not following the instructions, not applying the law. This verdict was reached on sympathy and on evidence that we don't believe should have been allowed to be presented to the jury with regard to the use of that word. We believe that, and again, respectfully, Judge, that they were misinstructed on disorderly conduct, whether disorderly conduct should be as a public offense or can be committed in your living room. There are First Amendment issues involved. Strict scrutiny should have been applied to the words and the language and the expression that was made in his living room. He should have the highest level of protection under the First Amendment for words that he uses in his own home. Also, that words can be a form of self-defense. We also believe that even if disorderly conduct did occur, that crime was completed before the stabbing occurred. These are all things we brought up at trial, Judge. Again, respectfully, we disagree with your rulings, but we believe that but for those rulings and had the jury been properly instructed, that Mr. Teslik would have been found not guilty had the law been properly set out for the jury. So we would ask that you grant a new trial and allow Mr. Teslik to have a fair trial based on the law and proper instruction.
Ms. Slaughter, since you did the resistance, are you making the Mr. Manning? Well, I guess Mr. Manning said second too. Mr. Manning?
Thank you. As the court is aware, the case law on the standard here is that a verdict is contrary to the weight of the evidence only when a greater amount of credible evidence supports one side of an issue or cause This weight of evidence standard requires Your Honor to consider whether more credible evidence supports the verdict rendered than supports the alternative verdict. Purportedly, the alternative verdict that the defense is arguing here would be an acquittal, since there were arguments made for any kind of lesser included offenses. At trial, the events that were key to the jury's analysis of the elements of the crimes involved were almost exclusively captured on video, including prior reactions between the parties in this case, supplemented by the explanation of physical evidence collected and testimony of witnesses that the jury heard. Despite the defense's arguments on their interpretation of the evidence, in this case, the jury clearly considered that and found that the greater weight of the credible evidence supported finding the defendant was guilty of the crimes charged beyond reasonable doubt, and unanimously in this case. The jury clearly found the defendant's actions of directing the abuse of epithet, knowing or having reasonably should have known and provoke a violent response constituted disorderly conduct. And due to those actions, as well as his use of unreasonable force under the circumstances, the jury obviously could have and did find that he was not justified. That being the sole defense really that was used in this case to the jury. That means that the alternate findings supported by the greater weight of credible evidence for all the reasons that we argued and for all the reasonable inferences from the evidence in this case would be a finding that the defendant was guilty as charged, as the jury found. Consequently, since the verdicts in this case are not against the weight of the evidence, the court should deny the defense motion for a new trial, and legal judgment can be pronounced. As for the reassertion of the arguments made pre-trial and during trial in this case, I believe that there was adequate record made at every stage here. We would reassert the state's position and or the court's findings on those legal issues, which were sound at the time they were made and remain sound at this time. Thank you.
And it is your motion, so the last word.
Judge, we would stand on the motion.
Oh, can you put back on your...
We would stand on our motion and our priorities.
With regard to the defense motion for new trial, I'm a little unclear. There's an arrest and judgment motion as well, and given some of your arguments, but so I will address as if there is one. But there are two different standards with regard to the arrest and judgment versus the new trial, motion for new trial. And with the arrest and judgment motion, that's in a light most favorable to the non-moving party, which in this case is the state. And though the court will go into a little more detail in its order with regard to case law, particularly the court's view that looking at the evidence in the light most favorable to the state, that a motion of arrest and judgment would be inappropriate with regard to disorderly conduct. given the word that was used and the circumstances, it would certainly give rise to a reasonable jury finding that a disorderly conduct occurred, and then given the circumstances in which the stabbing occurred, it would certainly, a reasonable jury could find that the stabbing occurred in circumstances that would have been murder except for the serious provocation that had occurred prior to that created essentially the impulse to kill, or the impulse to do the stabbing in part of the defendant. With regard to the weight of the evidence, that is, for the motion for new trial, that is a situation where the court is supposed to do an independent assessment of the credibility of the evidence itself. And however, the case law still makes it very clear that it's only in circumstances where the evidence can't, where it appears to the court that an injustice has occurred, because the way that the credible evidence is so against the verdict that it should not stand in a new trial, should be ordered. Again, I'll go into more detail with regard to the case law and that's in my order, but in State v. Reeves, for instance, they say the motion for new trial is governed by the way the evidence standard relying on new trial in the interest of justice so required. And it's broader than a judgment for acquittal or a rest of judgment motion. It involves weighing the evidence and considering the credibility of the witnesses. And it's when a miscarriage of justice resulted in the court's view in weighing all the evidence that the verdict in the court's view needs to be set aside, granting a new trial. But such an action should be exercised with caution and invoked only in exceptional cases in which the evidence preponderates heavily against the verdict. In this particular instance, with regard first to disorderly conduct, it's clear that even under the way the evidence standard that it doesn't heavily weigh upon, it does not preponderate heavily against the verdict. There's a specific word used and directed. It's not entirely accurate that it was, or at least the jury could have certainly seen that it was not exactly from his living room. He had opened the door, he was yelling outside the house. It was a racial epithet that credibly is abusive and would be, that any reasonable person should know would provoke a violent response, and given some of the history between the parties and the circumstances at that time, given the argument between Ms. Walker and the Ms. Chavez, that it was certainly obvious that such a statement would provoke a violent response, and the credible evidence supports that. With regard to the stabbing that resulted in Ms. Walker's death, once again, the video is also very clear with regard to this. For many of the reasons stated in stage resistance, the court concurs that the verdict is not one of those exceptional cases in which the evidence preponderates heavily against it. Ms. Walker was seen punching the defendant. She was not herself armed. The credible evidence does not heavily weigh towards that there was a potential burglary occurring in this instance. Given where the assault was occurring, where he was not even exactly inside his residence at that exact point, it was argued that by the defendant that he was trying to protect his daughter from being assaulted by Ms. Walker. The credible evidence doesn't support the notion that anybody would have thought Ms. Walker was going to start going after the daughter. It was clear that the defendant was her focus, and she was punching him in light of that. The credible evidence would support at that point that there was a right to self-defense. He was being punched. There was a lot of discussion about a duty to retreat. But at that point, that matter kind of becomes moot because he's being punched. So, at that point, he's being assaulted. The issue became, as was argued by the state, particularly in rebuttal, is whether or not he needed to bring the knife to what was at that point a fist fight. Was he acting in self-defense, or was he acting where he had snapped? And though clearly he had been provoked, and the credible evidence would support that he was provoked to the point where his anger was raised to such a level that he wanted to do harm, kill Ms. Walker. The credible evidence does not weigh heavily against the fact that under these circumstances, using a knife to stab her was a reasonable amount of force that was used. And that would qualify as self-defense rather than going beyond that, which is self-defense, but rather committing this act because he had snapped and he had enough in his mind and wanted to put Ms. Walker down. The evidence does not weigh heavily against that finding. And because of that, the court finds that granting a motion for new trial would not be appropriate because the credible evidence in the case does not ponderate heavily against the verdict. As far as the other matters that were kind of more generally asserted, and those were issues raised earlier. The court has done written rulings on those. There's not been any reason given in the court's judgment for to analyze those differently or do a different decision with regard to that, to any of those issues. So the court rules the motion as to those concerns too, and for purpose of time, we'll state a little more detail in the order, but suffice to say that the court is not convinced that it erred in rendering those prior decisions. So the defense motion for new trials overruled as well as any implicit motion for arrest of Are the parties prepared then to go conduct is a misdemeanor in violation of Iowa Code Section 723.4, subsection 1, subsection C. Is there any legal cause to be shown why judgment sentence should not now be had?
No, Judge.
I reviewed the pre-sentence investigation dated May 31st, 2024, prepared by Gene Shelton. Has the state had an opportunity to review it?
Yes, sir.
And has the defendant had an opportunity to review it along with counsel?
Yes, Judge.
Other than the recommendation of 60 days for the disorderly conduct, which the court understands is in excess of the maximum sentence for that offense, are there any other corrections, errors, or omissions to the PSI?
At one point, Judge, the PSI indicates that he's eligible for deferred. That's not the case on this charge. The only other thing we would do is ask that Exhibit Y be included with the PSI so that it follows to the Board of Parole.
I'm sorry, what was that last part?
So that it follows with the PSI to the Board of Parole. If we attach it to the PSI, then they'll get it.
Does the state wish to be heard with regard to sentencing?
Yes, sir. And we do have a victim impact statement that will be read by Ms. Baskin in our office from the victim's mother as well. Your Honor, due to the facts and circumstances of this case, the violent nature of the defendant's actions and his criminal record as set forth in the pre-sentence investigation, we're asking the court to impose the 10-year indeterminate sentence in this case. But for the defendant's actions that started with the history involved between these parties and culminated ultimately in his use of this abusive epithet towards Ms. Walker. But for those actions, Ms. Walker would still be here today. She'd be raising her children, but because of the defendant's criminal actions in this case, his violent and sudden stabbing of Ms. Walker, her 3 children will now live life without their mother. We're asking the court to impose the 10-year indeterminate sentence. We're asking for the court to order the defendant to pay $150,000 in victim restitution in this case, pursuant to the Iowa Code, and that the $150,000 be payable to LaShawn Bowles, who's the legal guardian of her 3 children. And those 3 children's initials, Your Honor, are AW, KW, and TW.
And how do you spell the name of the guardian?
Lesean, last name B as in boy, O-L-E-S, LaShawn Bowles.
And are you asking for the CBAP restitution as well?
Yes, Your Honor. And for the crime of disorderly conduct, for a 30-day jail sentence concurrent.
And are there representatives from the victim's family that wish to speak?
Unfortunately, Ms. Bowles is not here, but that victim impact statement will be read by Ms. Baskin.
That will be done after the defense has had an opportunity to speak. Does the defense counsel wish to be heard with regard to sentencing?
Judge, the sentence in this case is set out in the statute. You really don't have any choice but to impose the 10-year sentence. I do have to push back just a little bit. But for Ms. Walker's attack on Shane Teslik and his family in their own home, Ms. Walker would still be alive. Thank you.
Mr. Teslik, Iowa law requires that I give you an opportunity to address me before I render judgment. Is there anything that you would like to state at this time?
Judge, we also have letters that we'd like to read in as well.
but you're still wishing to have.
You do not have the one that was handed
Right.
to us today.
Right.
So if I may read that into the record. here.
Sure.
Your Honor, if I may read the statement that we received today. This is from Melissa Sidwell, who's the mother of my client's oldest child. Your Honor, thank you for the opportunity to speak in Shane Michael Teslik's behalf. I will briefly include comments for you as well. My name is Melissa Sidwell from Cedar Rapids. My mother and Shane's mother were best friends in high school until the present. My mother had me first, and then Shane was born when I was 9 to his mother, Patty. I remember helping take care of him as a baby. I wasn't involved much in his childhood, however. Over the years, my mother would let me know what was going on in their lives as they had moved elsewhere. I was in the same place at the same time when Shane was 19. We already had our past in common, and we developed a close friendship. Shane was such a good listener and gentle and happy. We settled differences quickly, as they were minor. He was the type of personality where he's easy to get along with and good natured. After almost a year, our relationship developed well, and I found out that Shane was going to be a father, and we were going to experience parenthood as friends. Shane was attractive to my needs throughout my pregnancy. Early on, we had a serious discussion about the future as respects to co-parenting. As I was a single mother of 3 daughters, I had to decide if he would cohabitate as stepfather in the immediate future. Within that context, I decided to be a single mother of 4, and Shane would be a part of Lennon's life in separate spaces. That decision made early on, like I said, Shane was still a young man during my pregnancy. So as friends, he took good care to make sure I was getting rest, eating healthy, and got to doctor appointments. In my opinion, that goes above and beyond in and of itself. Shane helped me through my labor and delivery. He stayed with newborn Lennon in the hospital. He was so happy to be a father. I mean, really excited. All of the times thereafter that he was supposed to take Lennon to have him at his apartment, he would. These arrangements were only verbal arrangements between us. What we had talked about and agreed to. Again, Shane was very good at communicating with me about these major life decisions. When either of us had to alter the plan, it went smoothly. Shane had his son over every single weekend up until he went to jail for 18 years. In fact, over the years, Shane and Lennon lived together for extended times, as I would need that due to my health. Shane always got him up for class, prepared him cooked meals, provided men's clothes, a clean house, Lennon's own room, materially, and yet he always paid child support on time to me, even during the times Lennon lived with him. By the time you're reading this, Shane would be separated for the first time in Lennon's life. Shane writes to him all the time, and Lennon writes to him. The impact of this guilty verdict was so heartbreaking on Lennon. He was beside himself, sick with grief. I would ask that you consider such circumstances when making a decision about sentencing. Please take to heart that Shane is an excellent father who spent all his free time with his son, and they are very close. Shane also has a 13-year-old daughter from Jesse Chavez. This daughter will consider Shane's, although Mackenzie's father really is someone else. Even before that man passed away, Shane was the only father Mackenzie ever knew, since she was very young. Shane loves his children so much. On many occasions, Shane broke down in front of my husband and I when he was going through this current situation. Shane would cry and lament being away from his kids in prison. This breaks my heart. Shane would never have let something like this happen, the death that is. Shane absolutely thought he was protecting Mackenzie from being brutally attacked, who was directly behind Shane at his apartment entry. Shane thought that Mackenzie would not have been spared. If Shane would have been knocked out, as she nailed him in the head several times and Jesse was already knocked out, then an infuriated pursuit into the inner apartment would have left their daughter an easy target. This seems likely as Lennon has informed me that Devonna had pursued the children on several previous occasions, directly calling them as children, racial slurs, and threatening them with bodily harm, brandishing a building club, and taunting them. Police records will also show these types of reports that Shane and Jesse made, naming her as a threat to Shane's family's safety and peace. Shane had these situations in his mind when he did what he did. It was the only way he could protect himself and his child and his knocked out girlfriend from further accosting or even murdering any of all or all of them in their own home. Shane would have never, I'm sorry, Your Honor, I'm going to start that statement all over again. Shane would never have a racist bone in his body. Lenon's best friend Earl, dark skinned, and would often go to their house to spend the night. Shane always took Lenon's best friend, LaBelle, to the movies with him, and then the three of them were regularly doing guy things together. Shane was like a dad to LaBelle. It should be noted that another testament to Shane's character that he's easy to get along with is that my husband put his own house up for bond when Shane was first arrested. My husband trusted Shane with using the house, the gift it was, with respect, and Shane did. Shane toed the line, worked every night, came over to our house regularly as part of our family. Please consider all of this. Thank you sincerely.
Judge, I'd ask the opportunity to amend our exhibit Y and include that letter with the affidavit here.
That's granted. Mr. Teslik, Iowa law requires that I give you an opportunity to address me before I enter judgment. Is there anything that you would like to state at this time? Yes, Your Honor.
Today I'm being sent to prison for protecting my family against a violent and brutal attack from a woman who was intoxicated with drugs and alcohol, whose violent attack on my family and I at our home was justified by the state because I said a word. Me or my family never put a finger on this woman prior to the night of January 2nd, 2023, when she attacked me and my family again. I did what was necessary as a father, a spouse, and a protector to my 12-year-old daughter, my fiance, myself, and our home against another violent and traumatizing attack by this woman, who again, the state said was justified to attack my family and I, not once, but twice, because of the night of January 2nd, 2023, I said a word to make her go away. What happened that night was the end result of the tragedy. I'm sorry for what happened. I'm sorry to the Walker family for the loss. That night could have ended differently in many different ways, both better and worse. My family and I's safety was my only concern that night, and I was going to do whatever necessary to ensure their safety. That's all I know.
State can present a statement from a representative of the family.
Thank you, Your Honor.
My name is LaShawn Bowles, and I am Devonna's mother. Writing this is incredibly painful, and each time I do, the tears flow more freely. This is likely the hardest thing any parent could ever face, sharing how a heartless, racist act of violence has devastated my family. Devonna was a loving and caring person. She always tried to feed people and loved to cook and party. Like many young parents, she still had some growing up to do, but she was so excited about having a baby girl. Now, because of this senseless act, she will never have the chance to raise her daughter. I am now left to raise 3 children on my own. Before January 2023, I didn't know the true depths of anxiety
Defendant is adjudicated to be guilty of the offenses voluntary manslaughter, Class C felony in violation of Iowa Code Section 707.4. In count 2, offensive disorderly conduct, simple misdemeanor, in violation of Iowa Code Section 723.4, subsection 1, subsection C. Judgment is entered accordingly. He is sentenced to be confined for an indeterminate term not to exceed 10 years. On count 1, his custody is placed with the Director of the Division of Adult Corrections. His temporary custody is with the Sheriff of this county pending transport to the IMCC. With regard to count 2, the court will order that the defendant serve 30 days in the county jail, with 30 days already served and credited. Also, that 30 days is concurrent with the 10-year prison sentence as well. Defendant is further sentenced to pay a fine in the amount of $1,370 along with the 15% surcharge. For count 1, there is no fine for count 2. Defendant's term of incarceration for count 1 may be reduced by as much as half the maximum sentence because of statutory good conduct, time, work credits, program credits. Also, the defendant may be eligible for parole before the sentence is discharged. The defendant shall pay victim restitution in the amount of $12,234.35 to the Crime Victim Assistance Program, and also $150,000 to the heirs at law of Devon Walker, who are the children identified as AW, KW, and TW, and the checks will be made payable to LaShawn Bowles, who is the legal guardian of those children. Plus, the defendant will need to make restitution for court costs, the amount established by the clerk of court, which as of April 2024 was $2,169.50. And subsequent to that, there's an expense of transcripts in the amount of $157.25 that will also be assessed to the defendant. And counsel, you were privately retained too, correct?
Correct.
Pursuant to Chapter 81 of the Iowa Criminal Code, the defendant shall report to the 6th Judicial District Department of Correctional Services to provide a DNA sample for DNA profiling. In addition, the state has made a request for the Office of the State Medical Examiner to pay the $2,925 reimbursement for extra witness fees, which the court will order as well. The reasons for the court's sentence with regard to the count 1 is the statutorily required sentence. It's a forcible felony and is not subject to suspension or deferred. With regard to disorderly conduct, due to the facts and circumstances and the nature of the epitaph and everything that had followed that, the court finds that the 30-day jail sentence is appropriate for that as well. The court believes that this sentence will often convictions, defendant's age, education, employment, family circumstances were also considered.